public assemblies. This time I think I'd like to ask Mr. Gottschalk. I'm sorry, Mr. Gottschalk. I know you were the council that was very involved in the creation of this ordinance, and I'm hoping that you will give us a brief rundown, overview of how it developed, where it developed from, and some of the highlights of it.
How much time do you have?
Yeah. We could be here all night.
Great.
I'm in for the long haul, Mr. Gottschalk. Just go right ahead.
I believe it's fair to say that this ordinance, this proposed ordinance, arose because there was a concern about unregulated expressions, outbursts of enthusiasm that occurred after a sporting event. And it was assumed that the way to address this problem was to adopt an ordinance that would establish a system that regulated parades. And I was asked, as a result, to prepare one, and I did. Actually, what I did was to go to, or actually Les Pinter went to the International Municipal Lawyers Association and seek a model ordinance on the subject of parades and public assembly. The interesting part about that is that what you have in front of you tonight doesn't really go to the heart of the motivation. When next October the Yankees win the World Series, two things will happen. One is that young people will flip over cars. They will hang out of their motor vehicles. They will blast loud horns. They will express their joy. And that won't be a parade. The parade will be the next week down the Canyon of Heroes. There'll be ticker tape. You've seen these? So two things will happen. One will be a violation of law, because we have laws against flipping over cars, or sticking your head out of a car, or blowing loud horns near hospitals. We have laws against that. And if you do it, you should be arrested, not given a permit. And then the second thing will happen. There'll be a permit. There'll be a system to make sure that when one group of people wants to express themselves to the exclusion of everybody else, that at least there's some way of making sure the ambulances can get to people, that there's a beginning and an end in terms of time, that police are available to control the crowds that you might anticipate attending such an event. And so, yeah, we got an ordinance here, proposed ordinance, and it doesn't address the first kind of thing, but it does do something that some of you may consider to be valuable, and that is to regulate what previously was not regulated. And some of you will, I'm guessing, disagree. But really that's what it does. It requires promoters, sponsors of parades or public assemblies, and there's a definition of both those things in the ordinance, to go to the chief of police, describe what they propose to do, where, when, how, and it allows the chief of police to review the application and grant a permit. There are standards established in the ordinance that the chief of police will use when evaluating these kinds of applications. There's a fee that is applicable except in cases where the intention, the reason for the parade is solely for the purpose of expressing speech, protected speech, establishes penalties for violation. How's that for a start?
Great start. Could you answer a couple of specific questions that were asked during the public hearing session? One of the questions that was mentioned that there was no funding in there for police department use. But I believe when I read it that there is a mechanism that the police could tell an applicant if it's going to require extra duty police that they will have to pay for that. Is that true?
It's true only in certain circumstances.
If it's required, if it's publicly required.
If we're talking about a special event where an application fee is paid, like a 10K race, then the applicant sponsor has to pay for police protection. This was a matter that was addressed.
No, I wanted to respond to your question.
Okay, well, I was asking that kind of, and then finish and then I'll...
Okay, because I can respond to the funding issue.
Okay, thank you. Are you finished?
I would hate to steal thunder because this was a matter that came up in the committee. It was discussed on a number of occasions, and the choice of the committee was to avoid the consequences that flow from a provision in an ordinance such as this that would tend to chill the expression of protected speech. If you say you can only express your position with respect to this government's participation in Iraq if you can afford to pay for police protection, then you tend to suppress that speech. And so rather than raise all of those kinds of questions, I believe that it was the position, at least of some members of the committee and others who were there, that this was kettle fish, not of oil.
Yeah, and I just wanted to mention the citizen that spoke and asked about the funding. Yes, there is funding in the current budget for parades in the amount of $25,000. So that should cover, let's hope, parades for the coming year. So that provision has been taken care of. I can't tell you exactly where it is, but the mayor's assured me that it's there.
Thank you, Mr. Chairman. And then the time limit, I remember seeing something in there about in the application, they had to put the starting time and the ending time approximately.
In both the application and in the terms and conditions that are to be expressed in the permit.
In regards to the fine limits, the $100 fine, does that go specifically to the organizer, if it's a organizer, or go to participants in the parade, or?
There's some case law that says that if you're going to charge someone for violating an ordinance with respect to freedom of speech that touches on freedom of speech, you have to not only show a violation, but you have to show the violation was knowing. So we've been very carefully crafting this ordinance to avoid some kind of blanket penalty that would attach to anybody participating in the parade, unless each one of them knew, for example, that there was no permit.
We'll open it up to the council. Mr. Trombetta at the end first. We'll start there.
Thank you. First of all, I want to thank Attorney Gottschalk and Attorney Pinter for their expertise in this area. I was on the committee. Actually, I was the chair of the committee. Not one portion of this particular ordinance was taken lightly. All individual rights were tried, actually looked at with a fine-tooth comb to make sure that the freedom of speech is protected. The charge of this committee was to acquire a process for a parade. I was shocked to realize that this town is large, this city as large as it is, had no process. We, in conjunction with Corporation Council, established a process. We didn't establish this lightly. Like I said, we reviewed every other town's processes and came up with the best possible plan. I truly believe it's a fine ordinance and one protects the rights of all citizens of the town, the city of Danbury. Thank you.
Thank you, Mr. Trombetta. Mr. Calandrino.
Thank you, Mr. Chairman. Through the chair to Attorney Gottschalk, is $100 the norm for a permit in this area, this region, for a permit to conduct a parade?
I've seen them higher, I've seen them lower, I've seen some ordinances with no permit fee at all. But the higher the permit fee, the greater the risk we run of a successful challenge. And the test is whether or not the permit fee relates to the cost of processing the permit application.
So that $100 is probably very reflective of what our administration costs are to process a parade application.
Well, I can tell you that I specifically asked the chief of police whether or not we would be able to sustain a $100 permit fee, and he told me with confidence that we would be able to do that.
Thank you, Mr. Gottschalk.
Mr. Chinis.
Thank you. Again, through the chair. I mean, I've been to all the committee meetings on this issue, so I'm pretty much familiar with a lot of the provisions in this ordinance, so I'm going to try to keep my comments pretty short. But when this ordinance first came about, I mean, I was pretty excited that the city was going to go ahead and try to regulate parades. But during its process, this ordinance changed 360. Originally, and this is one of my things that I wanted to do, is the cost of police protection is what drove this ordinance to where we are. But that was taken out. I believe that there should be a cost to the applicant for police protection. It's very expensive, even though it is budgeted at $25,000, that's still taxpayer dollars being used for a parade that they may not want. So I believe that it should be up to the applicant to bear the costs of whether or not it wants to have a parade, yes or no. So, I'm going to be voting against this ordinance, again, that's being one of the reasons. One of the other reasons also that it was expressed by the Chief Baker that he needed at least 5 days' notice to properly assure that there will be enough police officers on staff to handle any type of parade. This ordinance only gives... This ordinance only gives 3 days max notice needed, and so I believe we're an ordinance that's supposed to help organize a proper parade. I think it's going to actually charge more chaos, not basically to the taxpayer, but mainly to the police department. I think we're going to put a big burden on them to try to handle all these parade permits that could be coming their way. But just by the true nature of 25 more persons, that could open up the floodgates of thousands of parade applications. We just don't know how many that's going to affect. And there were several comments made tonight, length of parade lengths, time of parades, and it was also mentioned the penalty of $100. I mean, to me, if I was a parade organizer, I would violate this ordinance flat out. Therefore, I don't have to pay the $100, and I don't have to get the bond to hold the city harmless, which can run at least $500–600. So that's going to cost the average person at least $700 just to apply for this parade permit. And for a penalty of $100, I'll pay that. So I think there's a lot of holes in this ordinance that I think it needs to at least be addressed. But at the current, what's in front of us now, I would hope that this council at least vote against sending it to the council as a whole, because that's what I will be doing this evening. Thank you.
Well, this end of the dais first, and then I'll come back for a second round.
I'd like to respond to Mr. Chinese.
Saracino,
I'd like to respond to Mr. Chinese's comments. If you were at all of the meetings, you will recall the discussion that went on with regard to the fees. Attorney Gottschalk advised us that charging fees to people who are expressing their First Amendment right to free speech was slippery ground. And when we came right down to looking at who actually was going to pay fees, it came down to 2 or 3 clients. Those clients who are law-abiding, want to celebrate community event organizations such as the Portuguese Club and the Hibernians and the veterans. And they were the only people who were going to be charged fees for police protection, which, if you recall, the committee felt was unfair. And therefore, the fees were removed completely. So you can vote against the ordinance if you want, but there's no changing the protection of the First Amendment. The same is true with the 3 days and 5 days. If you recall the discussion, the police chief did in fact ask for 5 days. And we felt that that was burdensome to those who wanted to express their First Amendment rights, and therefore we chose to make it the 3, which gave people a little bit more impulse to react to world events or things that they might want to express themselves for. So each of those changes that you've contradicted there really are the ones that protect the rights of the residents of the city and their rights to assemble and their rights to free speech, which was, when all was said and done, the primary purpose of writing this ordinance.
Thank you, Mr. Seabury.
Thank you, Mr. President. I have 2 questions, and through the chair to Councilman Attorney Gacho. Thank you very much. I forgot what it is.
It's the heat, Mr. Seabury. I think
You're right.
understand.
Section 11-33, Rick, it says penalties. Any person violating provisions of any section of this article shall be subject to a fine not to exceed $100. My question to you, sir, is this. If, for instance, a permit is not taken out and there are some 400 people marching in parade because of a sporting event, and by the way, it's not going to be the Yankees, it'll be the Red Sox, and that's stipulated, are those 400 people subject to a $100 fine, or is it just each? Thank you. Isn't it nice that she's here to correct me? Would those 400 each be subject to that fine? Fine. $100.
All parties knowingly violating the provisions, that provision would be subject to fine. My guess is that the vast majority of people who see a parade because the Red Sox won the World Series
That sounds good.
aren't checking to see whether or not a permit was issued. They're just going to the party.
Yeah.
And it would be such an extraordinary party.
Thank you, Mr. Gacho.
From that, I believe, well, actually, Mr. Shelley is the applicant.
Thank you, Mr. President. Through the chair to the Corporation Council, could you highlight for me where the First Amendment protections are in this, or the exemptions, the language with regard to the First Amendment issue?
Sure. Let me start by saying that I believe, and I think case law would bear me out, when I say that parades are inherently expressive and therefore, by and large, implicate First Amendment freedom of speech issues. When you ask me to point out where it says so in here, I'm going to point to the provisions that exempt, for example, an applicant from the fee provisions or the insurance provisions, provided that the motivation for the parade implicates those reasons. That would be 11-19B, 11-21B. You could certainly make an argument that a standard in this ordinance implicates a variety of constitutional provisions, so I would point also to 11-22, 1 through 10, A, 1 through 10. 11-23 is titled Non-Discrimination. essentially indicates that you can't refuse to grant a permit because you don't like the content of the speech. That clearly implicates constitutional issues. Reason why we included 11-25, 11-24, 11-26, all relate to constitutional concerns of constitutional dimension. You have to give proper notice of a denial. You have to provide an alternative means to speak. You have to provide appeal procedures. You have to clearly identify, as we do in 11-30, what you can't do. I'm sorry, I've lost.
That's okay. You still have one, I'm still transfixed on your eloquent explanation. No, thank you, Mr. President and Corporation Counsel. That being said, I just want to make clear, there's not an express exemption for the exercising of First Amendment right to speech from having to apply for a permit. There are protections within this ordinance for those who are applying and waiving of fees and insurance requirements and the like. But to go back to what you said in your opening comments, this ordinance really doesn't, notwithstanding being, I think, well drafted into many different drafts, doesn't address the issue that brought this whole problem before us in the first place, which is spontaneous events. It expressly exempts them. They are not covered. The issue of a parade, a demonstration, a group of people all gathering because a particular sports team's win, they end up blocking the streets. There's laws against that already on the books. And they would expressly be exempted from any of the fines or provisions. So going on with what Councilman Seabury said, if the Red Sox won, and I agree with him, that would be a very good day, the World Series, that if people started all gathering together and parading down Main Street and then sitting in the center of West Street and Main Street, and someone ran up with this past ordinance and said, we're going to fine you. They couldn't, could they? Through the chair to Corporation Counsel. Under this ordinance, not other provisions of the law. Under this ordinance. So there'll be other provisions, traffic codes, other health, safety, welfare provisions of our ordinance, as well as state law that would apply to those types of actions. That's correct? That's correct. Going along with the issue of cost, one of the other things that brought this ordinance, or the initial phases of this ordinance before the council, was an allegation of discrimination with regard to charging organizers of parade the cost of police protection, that one organization was charged and one organization was not. Well, there's no charges here for police, and in fact, people have raised the issue that people should be paying some of the costs of coverage, particularly that in the case of the spontaneous events, which aren't covered under this ordinance. That being said, I have significant problems, and I've openly, Corporation Counsel has openly discussed this with me, these issues over and over again, and we've opined on constitutional protections and cases and ordinances across this state and other states. The broad application of this to a group of 25 persons or more, which includes demonstrations, picket lines, rallies and gatherings, even on a sidewalk that would block the use of that sidewalk by members of the public, really troubles me. To the extent that this would apply to those larger events, maybe another ordinance could do that. I don't see this ordinance doing what we wanted, preventing what we wanted to prevent, addressing what we wanted to address, and actually going further than what we initially expected. I will be voting against it, not because of the work or the drafting of it, but it just in principle, I think it goes too far, it doesn't address our concerns. And I urge my fellow council members to vote against it as well. Thank you very much. Thank you, Mr. President.
Pellegrino.
Thank you, Mr. Chairman. Through the chair to Assistant Chief. Good evening, Chief.
Good evening.
Chief, to your knowledge and experience, how many parades do we have that both are planned and extemporaneous a year?
We're not taking into account the World Cup events of every 4 years. It's in an average year, we're looking at probably 15 to 20 planned events, various feast days. That includes things such as the March 9 Walkathon and different events of that nature.
Okay, follow-up question. Has that been a drain on the police manpower, resources at all?
At times, specifically last year when we were short manpower, I think this year we're in much better condition to be able to absorb some of these issues. Some of the groups that do have these events notify us. Most of them do. And we make plans. We have a special events coordinator who gets with them, plans the route, and make sure everything's safe and we've got adequate manpower available.
And how many of those parades have been unplanned? In other words, just spontaneous people marching down Main Street?
I would say those would be limited to the ones after certain sporting events, the World Cup games that have been discussed. We've had short notice on some others in regards to some of the recent issues involving the immigration issue. But I don't believe any of those were unplanned. We also had advanced knowledge, and we did have some communication with some of the organizers, in which case we were able to get manpower in place to adequately keep the marchers safe and keep traffic flowing.
Were there any arrests made during those parades, any of those parades? Both planned and unplanned, or permitted or unpermitted?
During some of the celebrations that occurred, the spontaneous ones after the World Cup games last year, we did issue a number of infractions. It's motor vehicle infractions.
Thank you, Chief.
Mr. Carmetta?
Thank you, Mr. Chairman. Once again, I go back to remembering what the charge of the meeting was. The charge of the meeting was not it was based on a parade. We had a definition of a parade. That was the charge of the meeting. Based on the actions or the abilities of the police department to curtail or enforce local ordinances or laws, that was not the charge. They still have that jurisdiction. They still have that ability for any spontaneity, whether it be the winning of obviously the Italians winning the cup, which will happen again in 4 years, or any other type of parade. We do have that distinction. There is a distinction, and that was a charge, not to question the spontaneity, but actually a process for parades, which we did.
Let's start with Mr. Rotello and work our way down that way.
Thank you, Mr. President. Notwithstanding Councilman Trombetta's summation of the genesis of this proposed ordinance, much of it, indeed half of it, does not pertain to parades, but it pertains to gatherings and meetings. I don't know why they're there, but they are. And by voting for a parade ordinance, we are also voting for a meeting and gathering and assembly ordinance. With the council's indulgence, I will read, because it's important to get this into the record, section 1115-D, the definition of public assembly. It means any meeting, not some meetings or most meetings or even an occasional meeting or a specific meeting, but any meeting. Comma, demonstration, well, we know what that is. Comma, picket line, we sure know what that is. Comma, rally or gathering. Removing the middle of that, a public assembly means any gathering or any meeting, which the parade permit applicant believes will consist of more than 25 persons held on the streets, sidewalks, parks, or other public property owned by or under the control of the city of Danbury for a common purpose. Doesn't say what kind of purpose, it just says a common purpose. As a result of prior planning that interferes with the normal flow of pedestrian or vehicular traffic upon said streets, sidewalks, parks, or other public property. And they define what a sidewalk is and what a street is. But the ordinance is not restricted to sidewalks and streets. The language of the ordinance is very clear. It includes any public property. Now tonight we're sitting in some public property, and when we leave tonight's meeting, we'll go out in the hallway and probably interfere with the normal flow of traffic. Putting aside for a moment enforcement and interpretation, the language of this ordinance is clear. When we approve it, and it won't be approved tonight, it'll simply be voted up for the next council meeting, but when this is finally, or if this is finally approved, the minute that we approve the ordinance, we ourselves will be in violation. We will have a meeting of 26 people or more for a common purpose that will be interfering with the normal flow of pedestrian traffic. It doesn't stop there. It includes anything that takes place on any public property that interferes with the normal flow of traffic. I mean, that could be a football game, Pop Warner, 26 people or more. According to this ordinance, can't do it without a permit, and I don't know how much it's going to cost for the insurance. A funeral parade, not exempted. High school students going outside, sitting on public property at the high school on a nice day, biology field trip. Girl Scouts going to Terry Wild Park without a permit, can't do it. Any common purpose, any gathering, any meeting, any rally, in violation. Obviously, we've got things like picket lines and union organizations and things like that, but the scope of this ordinance for public assemblies is extraordinary. The language is clear. There are no exceptions for anything if you have 26 people or more gathered with prior planning for any public purpose without a permit, you are in violation. Now, you can talk about enforcement and you can talk about interpretation, and woe to any police chief who arrests a bunch of Girl Scouts selling cookies on the corner of South and Main at Rogers Park. Wouldn't stay in office too long. Woe to any police chief who arrests a bunch of people in Terry Wild Park orienteering or hiking. Wouldn't stay in office too long. But you get to the point where after not arresting and not enforcing an ordinance that we are in the process of passing, when the time comes to actually enforce the ordinance, because the behavior that is being perpetrated on the city is so outrageous it needs to be enforced, any good attorney will simply go to the court and say, look, these guys never enforce this ordinance. They're picking on my client. They are capriciously and arbitrarily, selectively enforcing this ordinance. I can cite you chapter and verse, and I'll bring in witnesses, Girl Scouts and orienteers and high school students and everybody else who have walked and assembled and met with impunity. Family reunions at the town park. After Thanksgiving, it's a nice day, you run down with 32 people to the town park at Rogers Park. You are in violation if you planned it ahead of time and didn't get a permit. Now, clearly no one is going to arrest these people, but when it comes time to enforcing this ordinance, when it needs to be enforced, my guess is any judge will look at this and say, Danbury, you really got to get your act together. You have created an ordinance that you never enforce. You have stated that you won't use it against the constitutional rights of assembly, but yet that's exactly what you are doing by cherry picking what you want to enforce and what you don't. I cannot vote for this. Thank you very much.
Thank you for the description, Mr. Riley.
Mr. Chair, please, Deputy Chief, please. Chief, if I would, a couple of questions, please. Are there laws on the books at this time that would be able to correct or to bring about a solving of a spontaneous reaction due to whatever, without putting an ordinance like this in place?
Depending on the conduct at the time, there are laws in place that regulate conduct in public places. I'm not sure if that answers your question.
In your opinion, would this ordinance enhance your ability or deter the police department from, with all of the requests for the different parade permits and everything, it's mind-boggling to me that we would put your department into this situation, but from your words only, do you think it would enhance your ability to the department? I put you on the spot.
I'm sitting here for Chief Baker, so here's what I'll tell you. Chief Baker supports this ordinance. He was concerned about the timeliness issue, the requirement of notification. He was hoping for more than 3 days. He did express that, and then I know he went to all the meetings and he did speak with Corporation Counsel regarding that. They came to an understanding on that. Title VII of Connecticut General Statutes currently gives the Chief of Police the right to assign people to areas of public amusement, public exhibitions where there may be a problem, where there may be crowd control issues. This ordinance, I believe in its intent, was to give us similar type authority to regulate parades in our street.
I have a feeling, this is an opinion, I have a feeling that we're opening up a can of worms. I mean, my God in heaven, if we're reacting to, which I have a feeling that this is what it's all about, a spontaneous eruption of emotions that might have taken place 6 months ago, a year ago, whatever, and we bring before this council a ordinance that wants to restrict something like that. It goes against something in me that says there's constitutional issues here. And I really feel like, I'll give you an opinion, I'll give you an idea. I was up on Deer Hill Avenue the other day, and immaculate high school track teams, both young ladies and young men, were coming up, going up and down Deer Hill Avenue, and I was on Deer Hill Avenue, and other being, you know, a fairly big guy, they would have ran me over. Well, in essence, they were breaking the ordinance, and what are you gonna do? You're gonna go to immaculate, and we're gonna fine them $100. I think that you just gotta face facts and say, listen, if we have an issue with a particular group or groups, well, by God in heaven, call a spade and take care of it. We don't have to take an ordinance to take care of the brownies that might want to meet on the street and march down saying, God bless America. I don't think we need to have them get a permit. I think this is ridiculous. We're going in the wrong way, and I'm going to vote hearty no. Thank you.
Saraceno.
Thank you. I'd like to respond to both Mr. Rotello and Mr. Riley. I want to congratulate Mr. Rotello and his imagination for coming up with all the incredible scenarios that he did. But he forgot that last part of the ordinance that says interferes with the normal flow of pedestrian or vehicular traffic. That doesn't include hikers in Terrio Island, brownies walking down the sidewalk, or the track team at Immaculate or anybody else. It means people that are blocking. And if you've ever been a part of a union, you know that a picket line can't block traffic anyway. That's against the law. So I don't know where you're coming up with all the scenarios, but I do not believe this ordinance addresses those in any way or intends to inhibit those in any way. And I think that bringing up those examples is just exaggeration, and I'm sorry, I just cannot buy what you're saying.
Thank you, Mrs. Saraceno. Through, I guess, the Chief of Police, or the Deputy Chief of Police, a question, if I might. Chief, close to what Mr. Riley was asking you, just in a more blunt answer, will this ordinance help your department with its logistics in providing public safety to the residents of Danbury? Yes or no?
Yes.
That's all I was interested in. And to Mr. Gottschalk, if I could ask you, sir, the provision for the insurance liability that is required on an approved application, that will definitely provide our residents with some level of protection against lawsuit in the event of...
I would far prefer having insurance to fall back on in the event of damage to personal property or injury to individuals than not having.
Thank you. Okay, who hasn't spoken on this issue for the first time? Mr. Visconti, I don't think we've heard from you yet.
No, I haven't. I just take offense, with all due respect to you, President Conway, asking a question that you just did to the Deputy Chief and putting him on the spot like that to give a yes or no answer. I just don't think it was
You
right.
take all the offense to that. You want Mr. Visconti all the way from here to Sunday. Mr. Rotello.
Thank you, Mr. President. Not only do my objections not connotate an excess of imagination, I have to say I haven't even thought of most of the issues that are going to come up, and I could reel off another 15 right now. For instance, when the visiting nurses come to Danbury to create a flu clinic, they, by their nature, stay in one place. And if they were to do it outside, which in some communities they do, particularly after disasters and whatnot, they stay in one spot. They are, by definition, blocking traffic. That's not some spacey thing that might never have happened in Danbury. It's already happened before. before. When the Girl Scouts stay in one place to sell cookies, they are by definition interfering with the normal flow of traffic. And reading this ordinance literally, which we have to do, we are creating a situation where these people have to get permits, and the permit itself is too expensive, coupled with the insurance, which is probably $500 to $600 or $700. It would simply mean that if I was running a charity event, I wouldn't call it in Danbury. It would simply, there would be too much off the top. $600 or $700 before I even got going. I do it in Bethel. These are not idle speculations. These are things that officers of organizations have to look at when they're deciding what they're going to do in a city. If they know in advance they are going to be violating an ordinance, and they don't feel like taking the chance that everybody's going to look away because it's such a nutty idea that you could possibly get cited for selling Girl Scout cookies on a corner of South and Main Street. If they're going to exercise their official responsibility, they're going to simply hold it someplace else or try to get a deferment. This is not the way to go. We're creating an ordinance here that we know with a wink and a nod will not be enforced against the good people, so that we can hopefully enforce it against the bad people. And any judge who takes a look at this after we start actually enforcing it 2 or 3 years down the road, at God knows what cost when we finally have to take this to court, is going to throw it out and admonish us. Let's fix it first. Thank you.
Mrs. Stanley?
Thank you, Mr. Cavo. I would just like to make a comment. I would really like to commend Attorney Gottschalk and the committee members. They were very hard on the ordinance. I did attend many of the meetings. I don't believe I attended all of the meetings, but I do believe this ordinance will only affect the law-abiding citizens that will follow the rules, and it will not pertain to anybody that is the reason why this was established in the first place. I think that the police department will do their due diligence to handle the problems that we have, and for the reason why this ordinance came before us. And that's just my opinion. I really don't think I will be voting on this. And I really do thank the committee members. I know they worked very hard on it. Thank you.
Mrs. Saraceno? Mr. Calabria?
Thank you, Mr. Chairman. You know, obviously it was felt that the town needed an ordinance regarding parades. So we went ahead and we put an ad hoc committee together. And they worked very hard. Now, I can appreciate some of the comments.
Mrs. Stanley and Mrs. Patterson. Okay, so that's 8 negatives, and that's 12 positive. Motion carries. Are there any abstentions? Carried. One.
Oh, and we have there's only 19. There's only 19.
All right. So it was. I'm sorry, that's right. Motion was to recommend to next regularly scheduled meeting of council that the ordinance. Okay, motion passes 11 to 8. We'll now move on to billing. Mr. Pinter?
appreciate the opportunity to be here in numbers for you.
A couple more, and we would have been in violation of something, I think.
What you have as next item on your agenda, Mr. President, is living regulations, item number 3, sections 11A-1 through 11A-6. This is a proposed entirely new section of the code of ordinances to address, as the term applies, living regulation. I won't be too long because I know that there are probably questions and the evening is getting late, but in essence, what the council should know with respect to this proposed legislation is that the mayor wanted to try to fold in and collapse all of the relevant littering statutes that would apply to the municipality together with the ordinances that we already had in place, which frankly were somewhat inadequate as well as somewhat antiquated. And so what we did was, at the mayor's request, is to look at the state statutes and draw in as much of the relevant language about the regulations that we could in order to propose an ordinance that could be applied locally using the best, if you will, the best of the state statutes as well as some of the existing local ordinance language that we had. There are 2-3 things that this proposed ordinance does. Number 1 is there are some adjustments, higher fines for littering and dumping regulations. Secondly, there are some broader prohibitions on littering and dumping based on the state law that we used. And thirdly, that the enforcement of some of these, of all of these sections, will also now be able to be accomplished with the use of the unit enforcement officials. And the third one is important because it gives us an extra tool to use personnel that we have to track this and to enforce it. The unit officials are not the exclusive enforcement agent, but they are an additional enforcement agent. Just quickly, I'll just tell you that the ordinance as proposed breaks down into basically 3 sections. 11A-2 addresses littering, that's your really retail littering, if I could use that term. Trash and garbage as defined by statute. The state law permits fines of up to $1,000 for this type of littering. Again, enforcement by the unit official, which is in subsection D of that. And what you'll see in your agenda as item number 5 also assists to fold in the permissibility of using the citation procedure for enforcement of these sections. And you'll see that in item number 5 later on in the agenda. Secondly, 11A-3 is your wholesale littering, if you will. That has to do with volume. It applies to dumping on public or private property. The statutes are very clear on this subject. We folded those statutes in to allow heftier fines for dumping, for public and private property. Also, enforcement is by the unit officials as well as through other means of enforcement that are available now. Finally, Section 11-A5 is a broad provision which allows and which promotes the mayor's intention, which is to provide a clean community. And that's one of the reasons why this set of statute or ordinance sections was entitled Clean Danbury, essentially. And that's intended to advise residents and businesses of the city that littering has to be taken care of. There has to be receptacles provided for establishments. People have to be more cognizant of littering and dumping in the city in its various areas. So those are the 3 primary components of this ordinance. And by the way, 11A-4, we drew that into this. That's really a restatement of an existing 1925 ordinance. It's actually fairly broad, so we were hesitant to delete it. So if you adopt this ordinance, that will show up in here, again, as an attempt to collapse all of the relevant littering and dumping ordinances into one section to make it easier for officials and public to track. So there we have it.
Thank you. What's your pleasure, Council? Mr. Tunis?
Thank you, Mr. President, and to Corporation Counsel. In reviewing this, I didn't notice any appeal process. Is that process not necessary in this type of ordinance to appeal?
The appeal process exists through the citation procedure in 12-35 of the ordinance. So if the unit official uses the citation procedure to enforce this ordinance, that appeal process that already exists will be used.
Follow up, is that mentioned in here? How would a common person know that if it's not referred to in this ordinance?
Right. Well, what we did was, because we draw in item number 5, unit official having the capacity to enforce additional sections over and above what other city officials can do, anything that the unit official can enforce includes the appeal procedures as already established. So if they do try to enforce it, 1235 draws them into the requirements for the process.
Follow up again. But again, do you think that would be a good idea to have that stated here, the appeal process, to draw you to that section of the ordinance? Just to be clear that it's there, so that people who read it know that there is an appeal process without searching.
To be honest with you, if it wasn't so prominent and highlighted in my mind where I thought that it should be in there, I felt that in preparing this and reviewing it, that it was sufficiently stated that the body and the understanding of the ordinance pertaining to citations, that would be clearly recognized. So I would not suggest you put it in here, certainly if you really want to be sure. But if you look at 11A-2 subsection D, the unit does refer to the unit litter control officer, and specifically refers to citations, and again specifically with respect to sections 12-34, 12-35. You probably wouldn't find separate language like that in other ordinance sections for other officials, because they all are drawn in by adoption of the official name into 12-35, and that covers you in those sections as well.
Mr. Simon?
I'd like to make a motion that we recommend adoption of the ordinance as presented to the full council May meeting.
Seconded by Mr. Trombetta. Is there any further discussion? Mr. Martello?
C, this would be 11A5C. Talking about construction, you're recommending that, or you're actually insisting that contractors provide the approved receptacle. And that's fine. I mean, you want to do that for large operations. But if you've got a guy who buys a new stove at Home Depot, puts it in, takes the old one out, puts it in his backyard for a couple of days before he can throw away, sort of a temporary transit from yard to transfer station. I mean, did you think about that, and what did you come up with, or is that something that hadn't occurred to you? Because it happens actually a lot with smaller operations, property managers and whatnot. They're taking water heaters out, they don't have any place to put them, and they're sitting in the backyard for a couple of days, and then off they go. They don't get a huge dumpster for this type of an operation.
Well, two things with respect to that. Number one is that all of these provisions must be interpreted in a way that's not reasonable. If someone does put something on the backyard, unless it's something that's of hazardous nature, or is blocking the way, or has the potential for some other damage, this legislation would be presumed to deal with that in a reasonable fashion, so that it's not intended to require Mrs. Smith to immediately go out the back door and remove the material. What it does require is that those who, for example, in this case, who are in the business, have access to the removal, to take advantage of that access within a reasonable time frame. Same with property owners. If, for example, property owner, for one reason or another, the weather's bad, or they simply don't have a way to take it out after a reasonable time, that's when you'll kick in this provision where it's been out there for a month or so, no efforts have been made, our unit official has acquired, they keep rejecting them. Under those circumstances is when you have the prospect of enforcement. So it has to be read in a reasonable fashion, which is what we do by
If I may, through the chair, is the word reasonable in here? I haven't memorized
It
the
isn't in
statute.
there, and we, in some cases, we like to put it in there, but in most cases, it's just the way it's interpreted. The courts will not allow us, frankly, to run away with enforcement that's unreasonable. So we go with the assumption that the court will look at this and say, you went over there, arrested Mrs. Jones, or fined Mrs. Jones after a couple of days, and you did so unreasonably. We will assume that's the way and challenge it will go.
I see. Thank you.
Okay, to help answer Mr. Councilman Vitella's question, I am now a new owner of a new boiler. I have a new dishwasher. I have all the stuff, all new stuff put in my house, which was hard stuff to. And do you know the selling point today is we will install it and take away your old one for free because we don't have to worry about you having it in the backyard and you have to worry about it. Or we'll take it away for $5 or so. And I think that's a selling point because everything was taken out of my house and nothing was left in the back of my house. And I think they did a great job and I'm glad they did. Thank you.
Okay, anything else? Littering? I'm sorry, Mr. Perkins? Take your time. Take your time. If you're ready, we're ready. Mr. Seabury.
Thank you, sir. One of the things that irritates the dickens out of me is crossing over the causeway at the lake, and whoever's doing it, it's been cleaned up before, but they go in the far back of that parking lot across from the boat launch, and there's just a multitude of garbage that's just dumped back there. That said, it appalls me, and to that end, I at this time would like to make a motion to recommend to the full... Who made it?
Right, we made it.
Thanks, sir. So we've agreed on two things tonight, Tom, the Red Sox and
Anything else? At this, Mr. Cheney's.
Thank you. Again, I think this is a very good ordinance. Those who were here on this past Saturday digging out mattresses, and I still got the scars from going down by the river, dragging out couches and hot water heaters and mattresses. I think this ordinance is a long time coming, and I would like to also make sure this all gets approved unanimously this evening.
Thank you. Mr. Perkins. Not a problem.
Thank you, Chair. I just have a question, Chief. When was the last time a $1,000 fine was given out for littering? If you
Top of my
can,
head, I couldn't tell you, Councilman, I have to research.
that's it, thank you.
Anything further? Seeing none, I'll try your minds. All those in favor signify by saying aye. Aye. Anybody opposed? Anybody abstaining? Mrs. Tendersack will be the abstention. Thank you. Let's move on to news racks and vending displays. Mr. Pinter. That's right, you didn't sit down.
Sitting down, actually. Thank you, Mr. President, Council. This is also a proposed new ordinance, again drawn from certain recommendations to try to improve the community. The mayor has been active in trying to ask us to try to formulate these kinds of protections. There really isn't any existing ordinance that we have now existing ordinance that addresses this issue. Again, if we had to draw back to something, it would be drawing back to some 1925 law pertaining.
Mr. Interviewer, please hold. Thank you, Mr. Pinter.
If you really look at it, we're left with some old law that might help Police Department has a hard enough time trying to interpret some of these ancient laws. So what we tried to do was to draw in the best of what we could find after doing the research in other communities, as well as research about the law in general for vending machines and news racks, or otherwise known as honor boxes, which, by the way, I hadn't heard that term before. Somebody said honor boxes. I said, what is that? That's what these things are. But in essence, the ordinance, and it's a little bit longer than the littering ordinance, but in essence, what it does is to establish standards, very important, if you try to regulate, particularly just went through the regulation of parades. It's very important to understand that these kinds of constitutional issues are very heady. We have to deal with them very carefully. We have to examine the law. In certain cases, the law can be a hindrance. In other cases, the law is a help. Here, I think we're pretty comfortable, we're very comfortable that the law is a help, because what we're trying to propose to you in this ordinance is a regulation based on health, safety, and welfare, not based upon content. That's very, if you take anything away from this presentation tonight, that's it. That what we're looking to do, what the mayor is looking to do, to assist in keeping the community clean and hazard-free, and to avoid other dangerous risks, is to provide not a regulation of what people have in these boxes, rather a regulation of where the boxes go, and to provide a mechanism for city officials, including unit officials, again, drawing them into the ability to enforce this, to give them the chance and the ability to regulate placement of these boxes. And if some of you, many of you have reviewed the ordinance, you'll see that, in fact, there's some language in there that says that this is not intended to be a matter of enforcement based on content. It's a matter of enforcement based on location, hazards, and risks. And that's where we feel that there is substantial support for the adoption of this legislation for that reason. There are permit processes in place, which you can see. There are limitations where such boxes can be placed, how they can be placed. It's a dancing act, a balancing act between the right people to put this stuff out. The law is pretty clear that you cannot stop people from vending on the streets. You just can't do that as a blanket matter. What you can do is regulate them in a fair manner, content neutral, the usual suspects, if you will, constitutional analysis. So again, what this does is, I'm not going to go through all the particulars, but it puts news rack and honor box owners on notice that if you have a box or boxes out there, you've got to kind of fix the location, you've got to remedy any bad boxes that are hanging over the curb, boxes that are falling over, boxes that are near the intersections. So you've got to remedy all those things. If you're planning to put some new boxes in, you can do that, but you have to come in for a permit, you have to comply with these provisions, and you have to be careful about how you maintain those boxes. That's essentially what the ordinance proposes to do. So, in sum, what you're being given is a means to regulate something that before really there were insufficient tools to do that. And again, I go back to the unit officials. They are empowered pursuant to this ordinance, as well as the police department, to assist in the enforcement of this legislation.
What's your pleasure? Mr. Raquel?
Thanks, Mr. President, through the chair to Attorney Pinner. I was really surprised going through this that we don't at present have any ordinances that prevent the obstruction of sidewalks. I mean, surely if I were to place a refrigerator in the middle of the sidewalk, brand new, let's say, not trash, and blocking traffic, I mean, there's got to be an ordinance against something. You can't just put things willy-nilly on our sidewalks, can you? Is that?
No, that's true, and what we do have, what the city does have, are some ordinances that go back quite a few decades that are very generic in nature. They really don't specifically address the kind of standards that we really need to do with things on the sidewalk. What those ordinances say is that the director of engineering, 1925, in those years, was the official in charge of these things. You can't leave things on the sidewalk or in the public way that obstructs traffic. That's in essence what the existing law says. But if you take the rubber band and draw it out, it really doesn't get too far, particularly with modern day honor boxes, that exist.
So you're saying that those ordinances, you couldn't use those ordinances to affect the behavior of people that are using these honor boxes?
I don't say that to you. You can use it.
If you could use, okay.
You can use it.
It's just not targeted. The other issue I have is that, it's not really an issue, but the holding harmless, which is, if I may, through the chair, 11B07. I'm glad to see this. We need something like this if we're going to allow these boxes by permit as opposed to by happenstance in designated areas where we're essentially authorizing these boxes to be put in, that we in turn don't wind up getting sued by people who fall over them or whatever. But I am concerned that the extension is not granted to private property owners. I mean, there is some concern with people who own property that if these were to wind up in front of their property, if the city deems it necessary to indemnify themselves, why didn't it simply extend that indemnification to all property owners? And I would like a motion, and I would ask you if we could do this without having to send this back, a motion with the indulgence of the council that we could also include private property owners in the indemnification process.
I wouldn't suggest that.
You would not? Why not?
Well, what we're trying to do here is really address the city's interests. There are lots of private interests out there. I couldn't begin to indicate to you how language like that would apply to private property owners. Because I don't know, number one, you didn't know what the relationship between the private property owner and the place where the box is. You don't know the exact location. You couldn't know private property exclusively. So I don't know if you want that in there. We certainly could look at that, but again, as I responded to a question before, that's something that really wasn't highlighted in our mind as being a critical factor. What we tried to do is simply to tell you that we need to protect the interests of the city and its residents as a matter of citizenship, not a matter of individual citizens.
If I may, what I mean is that if a box like this were to wind up on a sidewalk, on a public sidewalk in front of a private piece of property, not willy-nilly on somebody's front yard who's got a deal going with the Stamford Advocate. I'm just talking about you've got a store on Main Street and this thing winds up, or on Deer Hill or whatever, and it winds up on your sidewalk that you are responsible, as far as I know, you're responsible for maintaining the sidewalk. And you can't plow it properly, it freezes up around these boxes because you can't get your snowblower around it. Somebody slips on the ice as a result of not being able to clean it because the box is there. You can't sue the city because the city has indemnified itself, so you're going to sue. Well, you can't, because when we pass this, we will indemnify the city, so you can't sue. You can sue them, but I assume that a judge would throw it out. So you go after the next deepest pocket, which could be the Nolan Brothers or some other property management company. That's my issue.
And you probably only hold harmless somebody who's actually capable of being sued. So that's an uncertainty. It's too much of an uncertainty, frankly, to try to incorporate that into the ordinance. But what I will do, since it came up, I would take a look at that, and if there's an angle there that makes some sense, then it could be applied, certainly we'll get that back to you.
Appreciate it, Council. Thanks.
Corporation. Going to the actual permit, section 11B04, I was wondering, and hopefully this would not be a substantive change, I don't think it would be. The actual issuance of the permit, I know that a single permit can be issued for multiple news racks, but could we put some language in there without a substantive change that would require a public hearing, where the individual would be issued a sticker with the number on it and have to affix that sticker on each news rack? This way, any enforcing official could just glance and see which ones do or don't have stickers on them, much like a Weights and Measures or like any registered home improvement contractor. They just have to have that registration number. I think it would just allow for more rapid enforcement. The public could also notify the city.
Understood, Mr. Sadi. I would say that probably is a substantive adjustment. However, it can be done through the application of this ordinance if adopted by the officials who are charged.
And then just for the record, through the chair, and just to note for the record, I think the mayor is nodding in agreement with this, that we could do this administratively through the permit process, that there's a sticker and a requirement that it be affixed to the news rack.
Yes.
Thank you. Thank you.
Yes, I'd like to make a motion to adopt the ordinance.
Seconded by Mr. Trombetta.
To recommend we adopt the next recommendation,
seconded by Mr. Ferrand. Any further discussion? Seeing none, I'll try your minds. All those in favor signify by saying aye. Aye. Anybody opposed? Anybody abstaining? Mrs. Taversack abstaining. Okay, let's move to citations.
Mr. President, this is, number 5 is the proposed ordinance. This is not a new section, this is an amendment of an existing section, 12-34. All we're doing here is asking you to add 2 additional enforcement entities to the list of entities that you have already approved by previous councils in section 12-34. As you can see, B8, we're trying to suggest that the unit litter patrol officer was designee being authorized to issue citations, again, under the same procedures, including appeal procedures that Councilman Chianese asked about. And in section B9, the Director of Public Works would be authorized to issue those fines and, in essence, enforce Chapter 11B of the Code of Ordinance with respect to armed boxes. So, again, we're trying to neatly fold in the enforcement capability by citation, these 2 sections that you just
Thank you, Council. Mr. Rotelli.
Thank you, Mr. President. Through the chair to the acting chief and also to the unit officer. I'm a little concerned about granting police powers to people who haven't been trained in them. So what I would like to see is maybe some communication between the police and unit. If we can maybe give these guys who are going to be out on the street, naked, enforcing our laws, a little bit of protection, maybe some radios, they can get fast backup. I'm not sure if they're going to be weaponized or not, but it would seem to me that asking a guy whose métier is zoning enforcement to handle police powers without necessarily the proper training. I know police go through months of training, years of training, so maybe we could get a little give and take between the police and the unit.
Just quickly, I think the mayor wants to say something. The police powers should be taken in the context of what the intended enforcement is. For example, for litter and for honor boxes, it's not your heavy-handed, if you will, police enforcement. These are health, safety, welfare enforcement procedures. So there's a level of training that, of course, has to occur. Perhaps it's not the level of training that requires the firearm training, things like that. There may be other things that you guys do. But for these 2, I'm not sure we can go that far.
Well, if I may, I think about a situation where you're dealing with someone who's littering and intoxicated or doing something like that, and you blunder into that, and he's got a couple of friends, and the next thing it's escalated, and you don't know what to do because you haven't been trained. So that's an issue.
President, if I could address that. Part of the reorganization plan, the Chief's Vision 2009 plan, includes an officer that will work full-time in the unit. As soon as we adopt the pension regulations and finalize the contract and sign it, we'll be posting an officer to work in the unit, much like we have a community conditions officer that works with our downtown council. His or her job will be to assist the gentleman from the unit, will be there with them. So if you run into a situation where that happens, we'll have a law enforcement official specifically there. And also to address Mr. Chianesi's concerns, not trying to drag something else about parking, he'll be there to work with the unit as they look to enforce the parking regulations. So I think we have that issue covered. So we'll be working in direct supervision with police officers.
Thanks.
Anything else? Mr. Calabria?
Thank you, Mr. Chairman. I'd like to make a motion to receive the communication and adopt this ordinance the next scheduled meeting.
Please, motion recommend to the council.
Receive the communication and adopt the ordinance the next scheduled meeting.
Second on that? Who seconded that? Mr. Johnson? Any further discussion? Now I'll try your minds. All those in favor signify by saying aye. Aye. Anybody opposed? Anybody abstaining? Mrs. Taversack, any abstaining? Appointment, membership, and terms, Charles Eisenthal.
President, this is item number 6. Section 13A-58. This council has already adopted the larger proponents of the Charles Ives Authority for the Performing Arts, previously 13-56 through 13-60. What we're being asked to do here is to amend section 13-58 of that larger ordinance to permit the appointment in subsection B of 13A-58 of alternate members. There will be 3 of them to be appointed by the mayor and approved by the common council. So the language is the same as the appointment process for the 9 base members. And as you can see, the terms are for 3 years. So that's the extent of the substantive change. And if I may, while the opportunity is right, I'd like to just suggest that the council would authorize a clerical change in the opening paragraph of 13A-56, subsection A. The word before, in the third line, the word before the Charles Ives Authority should be capitalized, the word the. And after authority, the word of should be for. It did come to you in various iterations that way. I don't know why this happened, that we got this particular version. I do have prepared versions with those 2 clerical changes. So I would ask you to approve those clerical changes and consider the substantive change in 13A.
What's your pleasure, council? Mrs. Saracino?
I'd like to make a motion that we recommend to the council the approval of this ordinance at its next regularly scheduled meeting.
Seconded by Mr. Rotello. Any further discussion? Seeing none, I'll try your minds. All those in favor signify by saying aye. Aye. Anybody opposed? Nay. Opposition, raise your hand. Mr. Perkins, Mr. Visconti, and Mr. Seiden. And any abstentions? Mrs. Teverson. Motion passes. Let's move on to government entities. Charles Ives Authority. Mr. Pitcher?
Mr. President. Finally, we have this item. The committee that was formed to propose including the Charles Ives Authority for the Performing Arts, and as you can see, the correct title of the Charles Ives Authority is again correctly stated in the proposed ordinance. The committee that met on this, Councilwoman Diggs was the chairman of that committee, tried to, and if you look at the minutes from the meeting they had, I think it was February, the report was not read at the council meeting last month because of time commitments. However, what the committee intended was what you have here, which is to draw the Charles Ives Authority for the Performing Arts into the batch of boards, commissions, and authorities that would have the greatest length of time for existence before they were to be sunsetted. So what the committee intended, what we did, was just to put Charles Ives Authority into the June 30, 2007 classification. And what that would do is you're presently considering the reauthorization of numbers 1, 2, 3, and 4 of that subsection C. And if the council reauthorizes those 4, the motion that would be made would also draw the Ives Authority into that reapproval. So you would not be sunsetting the Charles Ives Authority on June 30th, because that would be an outcome that we would want. What you would be doing, and I think it's consistent with the committee's intention, is that as of July 1st, or whenever this batch of other reports and commissions is reauthorized, Charles Ives would ride away to 2012. So that's what this would do, and I propose the adoption.
This time I'd like to make a motion that we move to amend the Code of Ordinances, Section 2-176C, by adding as number 5, the Charles Ives Authority to be effective later of the date of reestablishment of that subsection C, or July 1st, 2007. This will take Ives sunsetting possibility out to June 30, 2012.
All due respect, Mr. President, it's a design officer permitted under our rules against motion. Chair, that has been made by
Pass that. Pass off the gavel.
Yes.
Majority request that I pass. Chairmanship off to Ms. Passo. I'll make a motion to amend the Code of Ordinances to Section 2-176C by adding as number 5 the Charles Ives Authority to be effective later of the date of reestablishment of that subsection C or July 1st, 2007. And recommend that the council adopt this at its next regularly scheduled meeting. Any discussion on it? Mr. Tom?
For the council that doesn't know, or maybe people in the audience, the only reason that we're doing this is because we want the sunset provision to last the full 5 years, and this was the only way we could figure out at the time to pull this off. So we're not sunsetting Ives, we're simply kicking it off in July, so it'll go the full 5 years and sunset when normal authorities are sunsetted, which usually lasts about 5 years. Thank you.
Any further discussion? Mr. Perkins? Seeing no further discussion, I'll try your minds.
I'm sorry, through the chair, are we talking about the sunset provision or the ordinance as a whole?
The ordinance that pertains to the sunsetting of the Charles Ives Authority.
So the next vote will be for the sunset, and then we'll have discussion on the actual ordinance.
No, it's all.
Let me just say what I have to say now. I just think that this is an overextension of the city in terms of financial and potential liability. I voted no for the appointments. I'll be voting no for this also.
No. Thank you, Mr. Perkins. Any further discussion? Seeing none, I'll try your minds. All those in favor signify by saying aye. Aye. Anybody opposed? Mr. Perkins, Mr. Visconti, and Mr. Sadi in the negative. And any abstentions? Mrs. Taverson. Thank you. At this point in time, seeing no further business before this committee, I'll entertain a motion to adjourn. Seconded by Mr. Cheney. All in favor, say aye. You abstaining from the? Mrs. Taverson will be abstaining.